So, thanks, Kathy. I just wanted to begin by taking a step back to say that there are a number of laws that have, there are a number of federal laws that have long been in place that could be used as tools to address many of what Kathy termed climate or environmental factors that occur in STEM. Now, some of those are in the employment context and, you know, Title VII and the Equal Pay Act and the Pregnancy Discrimination Act and the FMLA. All of those are tools that could be used to make some progress in terms of faculty. In addition, there are state laws that in some cases go beyond what's required by federal law that require state schools to take additional steps to recruit and retain faculty. But what I'm going to focus most of my comments on are Title IX and sort of following up on the GAO report from 2004. And although the GAO report in 2004 drew a lot of attention to the use of Title IX in the STEM application, I just want to be clear that Title IX has always covered STEM. And it's always covered all educational programs by recipients of federal funds. And as a result, all K-12 public schools and virtually every post-secondary educational institution has to comply with Title IX, because even $1 of federal funds is enough to trigger compliance. It's been most known for its athletics enforcement, in large part because there's been such great progress in that area. Now, although there's still a long way to go there, you know, it's not a small thing that competitive participation by female students at the post-secondary level has increased fivefold since Title IX. And at the high school level, you've gone from 300,000 to over 3 million female students participating in athletics in what's a pretty short time. But I mention athletics not because it's necessarily the model for enforcement in the area of STEM. There's a whole separate system of regulations and guidance that take into account the separate nature of male and female teams. But I mention it because I do think it's an example of where there is real attention paid by Congress and the administration and schools and advocates in a particular area where progress can be achieved. So I'll put that aside, because if I had an hour, I'd talk about everything, but since I now have probably 3 minutes, I'm gonna talk quickly. So as I said, much of the conduct and the environment and climate described by Kathy is covered by Title IX. Gender-based stereotyping or cold environments where women may feel excluded, that's covered by Title IX, and under the right circumstances could amount to a hostile environment. Or, you know, denial of tenure and promotions, or refusing to mentor female students or postdocs, or a tenure system that treats male and female faculty inequitably, or outright pay discrimination. All of those things are covered by Title IX and in some cases by other federal and state laws. But the question is, if that's the case, how can Title IX be a really effective tool here? It's not as if you need some new law to address it. And one of the things that came out of that GAO report is that there were few complaints filed to agencies of discrimination. So there were few Department of Education complaints, and there were few complaints filed, and in some cases no complaints ever filed, to the science granting institutions like NSF and NASA and energy. And so they looked at why that might be. And for faculty, one of the things that they focused on was that there was a real fear of retaliation. So if you were trying to be on a tenure track, filing a complaint, you might fear that that would take you quickly off that track. And that's not just true in the STEM fields, that's a concern across the board, but it's a real concern. Another is that if you're on a rigorous tenure track, would you want to take the time away from your research and your work and trying to further your career to file a complaint? And many people said that they wouldn't. And for students, they had no idea that Title IX applied outside that area of athletics, and certainly didn't know that it applied to the classroom and to their particular classrooms. So the idea that arose out of the 2004 JAO report and that many advocates had been pushing for was that these agencies could fill the gap left by the complaint process. By having agency-initiated assessments of these institutions, it gave an opportunity where the burden is not necessarily with the students and faculty to raise all the various concerns that they may see in ways that might make them feel like they're targets, but it also allowed for a dialogue about how to make college campuses the types of campuses where students want to stay and learn and continue on the pipeline into rigorous sciences. So some of these compliance reviews have begun, and they're going to be more, and I hope they will continue to be really robust. And one of the things that I want to highlight is the difference between a compliance review and one that can be even more robust. So it's one thing to conduct a compliance review and assess whether you have processes and procedures in place at all. So do you have a Title IX coordinator? Do you have a Title IX policy? Is there a grievance procedure to file complaints? And it's another thing to see how those processes are used and what actually happens on the campus. So if a compliance review shows, well, in the past 3 years, there have been no complaints. And the interviews show that many of the students feel like there's a pretty cold environment that's sort of unwelcoming, that they don't see a path for achievement for them. It seems like there's a little bit of a disconnect here. So it may be, if there are no complaints, that there is no problem. Or it may be that the grievance procedure is so complicated no one knows how to begin to use it. Or it may be that the person who handles grievances is the person who harasses. Or it may be that there are so many steps to take that who would want to get off the tenure track or get off whatever track they're on to go to the next level in their field. So there's a way to do it that's sort of more robust at the front end. And then the last thing I'll say is that there's a way to do it that's really more robust on the back end, because one of the great things about compliance reviews is that they permit agencies to acknowledge where there are gaps and to highlight best practices and to highlight where there are violations of the law in a way that can be done with timeframes and goals set by the agencies in an agreement with an educational institution. And in some cases, some levels of remediation may be in order. And in some cases, like the Notre Dame example that Kathy gave, it may be that there can be creative measures put in place to address the situation that they hadn't thought about. So the last thing to make it really robust is that the ultimate plans and compliance plans that the agencies and universities come up with, if they could be publicized, then the colleges and universities who are thinking about, well, what should I be doing on my campus, if they don't have the opportunity to be visited in a compliance review, and I think that they should think about it as an opportunity, although I suspect that not everyone does, but if they don't have that opportunity, they could be implementing some of the creative remediation type measures that come out of these reviews. So I want to leave some time for questions, and we'll turn it back to Lisa.